Welcome to This Explainer. Today, we are taking something that might normally put you right to sleep, a sprawling piece of legislation called the Copyright Act 1957, and we're translating it into a highly practical, incredibly powerful toolkit for creators and users alike. We're going to map out the entire journey of a creative work, literally from the second it's born to the moment it enters the public domain. We're mapping the exact legal architecture behind your creations. Okay, so here is our roadmap. We are covering 1. What is copyright? 2. Who owns the rights? 3. How long does it last? 4. Sharing and selling those rights. 5. Breaking the rules. And finally, 6. The fair dealing exception. Let's jump right into Section 1. What is copyright? The birth of a creation. I want you to imagine the very moment you create something new. You've just finished typing the final line of code, maybe painted the last brushstroke, or recorded a brand new melody. At that exact moment, an invisible legal shield wraps around your creation. According to the Act, this shield protects a really vast array of works: original literary, dramatic, musical, and artistic works, as well as cinematographic films and sound recordings. And what's amazing here is just how broad this legal definition is. You know, literary works doesn't just mean poetry and novels. It explicitly includes computer programs and databases. Artistic works cover everything from a quick sketch on a napkin to a complex architectural blueprint or even a towering sculpture. If it falls into these categories, it's immediately eligible for protection. But what's really fascinating here is that copyright isn't just one single monolithic rule. Instead, think of it as a bundle of rights. It gives the creator exclusive control over exactly how their work is experienced by the rest of the world. You hold the right to reproduce the work, issue copies, perform it publicly, translate it into another language, or adapt it into something entirely else, like, say, turning a novel into a movie. You hold all the keys to these different doors. Moving on to Section 2. Who owns the rights? Identifying the first owner. So we know what copyright is, but just because you made something, does the law actually say you own it? Well, you might be surprised. The bedrock principle of the 1957 Act is that the author of a work is the first owner of the copyright. But author is a very specific legal term here. For a book, sure, it's the writer. But for musical works, the author is the composer. For a photograph, it's the person who physically takes the picture. And for a cinematograph, film, or a sound recording, the author is actually defined as the producer, the person who takes the initiative and the responsibility for making the work happen in the first place. And this brilliantly illustrates a massive nuance in the law. Context matters entirely. If you're an independent creator working on your own time, you are the first owner, full stop. However, if you're creating something as part of your day job under a contract of service, your employer is actually the default first owner of that copyright, not you, unless you have a specific agreement written down that says otherwise. Your boss owns the entire bundle of rights for the work you create on the clock. Let's test your new legal intuition with a very relatable scenario. Imagine you hire a professional photographer to take pictures at a family event, or maybe you commission an artist to paint a portrait for your living room. Who owns the copyright? The person holding the camera or the person who hired them? Take a quick mental guess. Okay, here's the punchline straight from the Act. If a photograph, painting, portrait, engraving, or film is made for valuable consideration, which is essentially legal speak for holding the purse strings, getting paid or compensated, the person who commissioned the work is the default first owner of the copyright. So, yeah, you own the rights to that commissioned portrait unless your contract with the artist specifically states otherwise. All right, Section 3. How long does it last? The lifespan of protection. We've established birth and ownership, but copyright protection absolutely doesn't last forever. Eventually, everything enters the public domain. So how long does this shield last? Well, the crucial point is this massive number right here, 60. 60 years is the magic threshold that repeats over and over throughout the Copyright Act when determining the lifespan of protection. But exactly when that 60-year countdown starts, that depends entirely on the type of work. Let's break down this timeline. For your standard literary, dramatic, musical, or artistic works published during the creator's lifetime, the copyright lasts for the entire lifetime of the author, plus an additional 60 years following the year they pass away. That is a multi-generational shield. However, for cinematographic films, sound recordings, government works, or works published anonymously, the countdown is quite different. For these, the clock simply runs for 60 years, starting from the calendar year next following the year the work is first published. Moving into Section 4, sharing and selling rights. The marketplace. Now, this is where copyright transforms from an invisible shield into a tangible asset that you can actually license, assign, and profit from. If you want to transfer your copyright to someone else, a process the law calls assignment, you can't just do it with a friendly handshake. The Act demands strict formalities. To be legally valid, an assignment must 1. Be in writing and signed by the assignor. 2. It has to explicitly identify the work and exactly which rights out of that bundle are being handed over. 3. It must specify the duration and the territorial extent, meaning where in the world this applies. And 4. It must clearly specify the royalty or consideration payable to the creator. It's a highly protective checklist. But here is a truly incredible, lesser-known insider secret tucked right into Section 19 of the Act. What happens if you sign a contract assigning your copyright, but you just forget to write down how long the assignment lasts? The law doesn't just assume you meant forever. Instead, the law automatically defaults the duration to just 5 years. And if you forget to specify the territory, it defaults to only within India. It's a massive built-in safety net for creators who might sign incomplete contracts. Now, navigating this marketplace can be incredibly complex. I mean, how does a songwriter track every single radio station playing their track? The answer is, they don't have to navigate it alone. Creators can join a copyright society. These are registered associations heavily regulated by the government. Authors entrust their rights to these societies, which then take on the heavy lifting of issuing licenses, collecting the fees from businesses and broadcasters, and distributing those royalties right back to the creators. It's the ultimate power of collective control. Section 5. Breaking the rules. Infringement. So you know your rights, you know how to sell them, but what happens when someone decides to bypass all of that and just uses your work without asking? The law defines infringement with some very exact, biting language. Infringement occurs when any person, without a valid license, does anything that is exclusively the right of the copyright owner. If you hold the exclusive right to reproduce a film and someone else makes copies of it without your permission, they have breached your legal shield. The Act specifically targets commercial exploitation by rule breakers. Actions that will definitively land someone in hot water include making infringing copies for sale or hire, displaying them by way of trade, or distributing them to such an extent that it financially hurts the original owner. Even importing infringing copies into India is explicitly categorized as a severe violation of the copyright owner's rights. And finally, Section 6, the Fair Dealing Exception, the Balancing Act. Look, copyright is incredibly powerful, but it isn't absolute. If nobody could ever use a copyrighted work without permission, society would stall. Education would freeze, and the news couldn't even be reported. Therefore, Section 52 of the Act outlines crucial exceptions, primarily centered around a concept called fair dealing. Certain acts are explicitly not considered infringement. If you're using a work for private personal use or conducting academic research, you're protected. If you're quoting a book to write a criticism or review, or if a journalist is using excerpts to report on current events, that's fair dealing. Importantly, reproduction of a work by a teacher or a pupil during the course of instruction is also heavily protected. These are the vital loopholes that allow culture and education to interact with media on a daily basis. To truly understand this balance, check out this direct contrast within the law. If a person permits a venue to be used to publicly play a copyrighted musical work for profit without a license, that is absolutely infringement. However, if that exact same musical work is performed by an amateur club for a non-paying audience or for the benefit of a religious institution, the Act categorizes it as a completely protected exception. The law meticulously divides commercial exploitation for profit from genuine community and educational benefit for non-paying audiences. Well, we've traveled through the entire life cycle of a creation under the 1957 Act, from its birth and ownership, through its 60-year lifespan and marketplace assignment, all the way to infringement and fair dealing. So I want to leave you with this provocative question to ponder. When was the last time you really read the fine print on a contract for your creative work? Armed with this new legal scaffolding, I urge you to look closely at your next agreement. Make sure your bundle of rights is actually working for you, not against you. Keep learning, keep creating, and I'll see you in the next explainer.